everybody. And a very warm Inclusion Ireland welcome to this webinar in conversation with Áine Flynn, the Director of the Decision Support Service. Áine, a very warm welcome to you and thank you sincerely for joining us this morning at Inclusion Ireland. We've had huge interest in this webinar. 152 participants signed up to it, and we had multiple people contacting us asking for a recording as well, which we're pleased you've agreed to that, so we'll be able to share it widely afterwards. So I'm just going to do a brief introduction first, and then I will hand over to Áine, who's going to do a brief presentation for family members. And then the rest of the session will be an in-conversation between Áine and I, where I'll be able to share some of the questions that have arisen from our communication with family members across the country over the last few weeks. So I'll keep my piece pretty short and snappy, if that's okay with everybody. But just for people who aren't maybe familiar with Inclusion Ireland, just to give a brief overview of who we are and what we're about. So I suppose Inclusion Ireland are the national advocacy organisation for people with an intellectual disability. And our sole purpose is to work towards the full inclusion of people with intellectual disabilities by supporting people to have their voices heard and advocating for rights under the United Nations Convention on the Rights of People with Disabilities. So what we do, we're a campaigning organisation and we work for changes in legislation and policy. We provide an accessible information and signposting service for people with intellectual disabilities and family members. And this means when people call or email us, look at our website or come to our talks, we help them with information about their rights. We support other organisations to become more accessible and inclusive of people with intellectual disabilities. We hold the state to account for its progress with the United Nations Convention on the Rights of People with Disabilities. We support people with intellectual disabilities to become self-advocates, and we're at the table wherever people talk about the rights of people with intellectual disabilities, and we work to influence thinking. I suppose we support the full inclusion of children and adults. We work towards fully inclusive schools, communities, and workplaces, and we really want to make sure that people with higher support needs who may be non-speaking have a voice in all of our work, and we try and find ways to make sure that this happens. And we want to change the language and story around care and independence. We know that no person exists on their own. We all need support. Some people need a little bit of support, others need a lot of support, and this can change over time for each person. And all of our work is through the prism of the United Nations Convention on the Rights of the Child and the United Nations Convention on the Rights of Persons with Disabilities. And we understand that as humans, we all want connection, belonging, community in our own way. And we're very proud of the fact that we're builders, not bashers. Our job is to point out all the problems, and there are many problems, and the inequalities, but we also focus on building better systems and supports for people. We want to be part of the solution, and we work with government, state agencies, and others to make change happen. So that's in brief a whistle-stop tour of our work. And I suppose without further ado, I would just like to welcome Áine Flynn, who has joined us this morning as the Director of the Decision Support Service. And before we get into our conversation and the question and answer conversation, Áine is just going to give us a brief update and presentation about the work of the Decision Support Service. And I'm sure, Áine, we're particularly grateful for you joining us today, because I'm sure the last 2 weeks have been incredibly busy as the doors of the Decision Support Service finally opened after that long awaited time. So we're particularly grateful that you've joined us today and prioritised, I suppose, family members of people with intellectual disabilities who might have a lot of questions, might be very excited about the Decision Support Service opening, might also be concerned, worried, have fears and anxieties. And I suppose that's what today is about exploring all of that and giving people information that they need. So I am going to stop sharing my screen if I can. 1 second. Alex, are you able to take that down for me? Sorry, for some reason the stop share has stopped working. Thank you. Great. So Áine, I'll hand over to you for the next few minutes.
Thanks so much, Derval, and thanks very much to Inclusion Ireland for the invitation to speak today, and for all of the support and collaboration that we've had. It's really been hugely valuable, and most recently, as Derval knows, we engaged in relation to identifying champions, some of whom are from the Inclusion Ireland family, who have become the faces of the decision support service, and that's been really valuable. And I think, they're able to say more eloquently than any of us what the Act and the work of the decision support service could mean for them. So that was really great. Yeah, I will. This is a shortened version of a longer presentation, but might just hit some of the key things about the Assisted Decision Making Capacity Act and the Decision Support Service, and I'm sure we'd be able to draw out more of that in the Q&A. Lots more information, as I'll be saying at the end, is available from the Decision Support Service in various ways. So the Act finally came to life a couple of weeks ago, 2 weeks ago yesterday, on the 26th of April. So we're talking about the Assisted Decision Making Capacity Act of 2015. It was fully signed into law then more than 7 years ago, and became operational law just in the last 2 weeks. So it's such a mouthful, I generally just say the Act or the 2015 Act. So when it came to life on the 26th of April, the Decision Support Service began full delivery of all of our functions. We've been up and running for several years in terms of our information and guidance functions, answering questions, engaging with the public for quite some time. And we've had a website since August of 2020, for example. But now we begin our role in relation to the registration and supervision of new arrangements under the Act where people need them. So this is some of the things that the 15 Act does. It's about fundamentally how we support people in their decision making. As I and others have said, if you think about the brackets around capacity there, this isn't some new prescriptive act about how we assess capacity and how we access people's consents. Fundamentally, the starting point is about how we support people making their own decisions, and moving only to think about formal supports as and when they are required. So some of the key things that the Act has done is to abolish the existing wards of court system for adults. All adult wards will have their cases reviewed by the wardship court and are coming out of wardship. And if that matters to someone in the audience here, if you've got questions about that exit from wardship process, those are queries for the Office of Wards of Court, but we can point you in the right direction if that's your particular concern or interest. The Act puts on a statutory basis, in other words, writing into an Act of the Oireachtas, this functional approach to capacity. There are guiding principles, the new framework for supports, new tools for all of us to think about advanced planning, and the Act establishes us the Decision Support Service. And the Act applies only to adults over the age of 18. Maybe over time it will move to young adults, perhaps 16 and 17-year-olds, but for the moment only those over the age of 18. And when you think about capacity now under the Act, it's called this functional approach to capacity. The Act doesn't use the words mental capacity. The idea of somebody just lacking capacity is gone, and has been gone for some time, actually, because the courts have already said a long time ago that this is the correct approach. So it isn't about a diagnosis, it isn't about a medical approach to capacity, it isn't does somebody have an intellectual disability, but rather what's the thing that a person needs to decide, and are they able to decide it? So you lack capacity isn't a full sentence. And if it's necessary to assess capacity, and it's very much not what you do first, then the question is thinking about the decision to be made. So perhaps it's a decision about managing a sum of money, or a decision in relation to healthcare, for example. Is the person able to do the following? Understand the information relevant to the decision, retain that information for long enough to make a voluntary choice, use and weigh up the information, and communicate their decision. And that's communicate however they communicate. As Derval has said in her opening address, people might have particular tools around communication, assistive technology, the support of the person who knows them best. Those tools should be made available. Those ways of communicating should be facilitated. And the fact that they are required is no indication that a person lacks capacity. So understand, retain, weigh up, communicate. Those are the features of capacity. but you don't, as a starting point, assess a person's capacity. And I think that's clear from the guiding principles, the first of which says that an adult is presumed to have capacity to decide the thing unless the contrary is shown. So this has been the law, like the functional test itself. This has been the law for many years, that an adult, irrespective of how they present, is presumed to be able to decide, and the burden isn't on that adult to show that they can. The burden is on the person who's suggesting that they can't. And if they cannot, then that is shown in that functional way. And then you think, well, where are we now? What do we do in order to support decision making? But the starting point is that a person is able to decide the thing. And as I've said already, I think the Act is strong on this next point about supporting people as far as possible, providing the help they require in order to make their own decisions. Deciding to do an unwise thing doesn't mean that you don't have the capacity to decide to do it. That's not saying that we all get to do unwise things. You know, we have rights, but we live alongside other people who have rights as well. So sometimes this is and I used to say it in the past myself, it can be misleadingly shortened to this right to be unwise, which can strike people as a bit of a free-for-all. No, the Act is saying that the fact that what you want to do seems unwise doesn't mean that you're not able to decide to do it. Derval has mentioned the United Nations Convention on the Rights of Persons with Disabilities, which Ireland ratified more than 5 years ago. And a lot of the guiding principles in this Act are informed by the Convention. So we see principles about intervening as little as possible, the minimal restriction of a person's rights and freedoms, respect for everyone's dignity, privacy, bodily integrity and autonomy, allowing people, as we've said, to make up their own minds as much as possible and to be included in the decision making that matters to them. I put the next one in bold because it's considered to be really fundamental to the UN Convention. The UN Committee, certainly for the Convention, have emphasised that the starting point is giving effect as far as possible to a person's will and preferences instead of a best interests approach. So the starting point is, what does this person want, rather than what is good for them, acting always in good faith and for their benefit. And you will see that will and preferences phrase mentioned at different places throughout the Act. It's considered to be really important to the legislation. And these are the sorts of decisions that are capable of being supported. That's not saying if somebody has one of these decisions, they now need to have their capacity assessed and they need to move into the new framework. Rather, here are the sorts of decisions that are decisions as defined under the Act. So they can be property and affairs decisions or personal welfare decisions. And I won't go through the full lists, they're quite broad. So property and affairs decisions could be anything about for benefits, managing bills, managing bank accounts, involvement in court proceedings if people have that. So it might be that somebody needs supports around those and then they're capable of being supported under the Act. Personal welfare, broader again, decisions about accommodation, including living in a designated centre, decisions about education and training, social services, healthcare, which can include treatment decisions. The Amending Act last year slotted in here decisions about participation in research, but not including clinical trials. And then the really broad other matters relating to the relevant person's well-being. So if somebody has decisions that fall into these categories, and if they need supports, then these are the sorts of decisions that may be supported. Some things are outside of the framework. So in this case, the Act is saying there's no change to the law in relation to some matters, which would mean that a decision supporter couldn't be involved in decisions about a limited list of things. So you can't have a decision supporter deciding with you or for you whether you're getting married, or whether you're going to get separated or divorced, or decisions around guardianship of a child or placing a child for adoption, consent to sexual relationships. The existing law on consent and capacity is unaffected by this Act. Serving on a jury, you can't have a kind of somebody who comes along to help you serve as a jury under this Act. So there's just a practical list of things which are outside of the Act and not on this new framework. Now, I'm not going into the framework in detail here, but this is an overview of it. So you have the bottom tier decision-making assistant providing just practical supports about gathering up information, helping the person communicate what they want to do, but the person is still deciding. Co-decision making, as the name suggests, is a process for joint decision making. That's more formal. It's registered with us. We supervise its performance. There's lots more information about the whole framework available from the DSS. And the top tier is still a court appointment. And that could be as an outcome of a new application to court. And I see some of the questions are about those court applications. Or it could be that the wardship court reviewing those exiting wards decides to appoint a decision-making representative. So again, that comes to us for supervision, and we will try and make sure that it works well and everybody understands their role. So those are the three steps as you go up them, all have to apply those guiding principles, including that important respect for will and preferences. And who can be a decision supporter under the Act? Well, ideally, as the Act spells out, the decision supporter is going to be somebody close to the person and in a relationship of trust. And I see some of the questions are about that as well. In fact, at that bottom tier and the middle tier, it has to be somebody that you know and trust. A co-decision maker has to be a relative or friend. So this isn't about the professionalization of decision making. It's about drawing on your natural supports and where you need to, appointing them in a formal way, but only where you need to. So the first call, obviously, is on those close to you who know you best. The Act sets out certain grounds in which a person is ineligible to be a decision supporter. So you wouldn't be able to step into one of these roles on the basis of certain criminal convictions or a history of barring orders or safety orders. Or if the decision making is about property and affairs, then people might be ruled out on the grounds of bankruptcy or insolvency, and those are spelled out in the particular support arrangements. And if the person is in a designated centre or a mental health facility, then the owner or the registered provider or somebody working in that place isn't eligible to step into one of these roles. I think the idea being, look, if you're delivering care to a person, if they're living in a facility that you own or run or work in, then you shouldn't at the same time have a role to decide for them or with them about their resources potentially. I always mention planning ahead because this is an Act that matters to everybody. There are two ways for everybody to plan ahead when they've capacity to do so, either by way of an enduring power of attorney or by way of an advanced healthcare directive. So EPAs have existed since an Act of 1996. And if you have a 1996 EPA, incidentally, that's still a valid document and you don't need to do a thing with it. So any exercise in advanced planning consists of you with your capacity deciding who's going to step in if you didn't have capacity at a future time. What is different is that if somebody makes an EPA now, they're doing so under the 2015 Act, and we supervise the EPA like we do the middle tier and the top tier that we just looked at. And there's a new approach to doing these. So you register them with the DSS, so we're able to check them out, make sure they're going to work if they need to later on. And we keep that in a register. And then it's the second stage is when it's notified to us if you lose capacity, your attorney is then able to step in. So as I say, this is an Act for everybody. We know not when we mightn't be able to take our own decisions in the future, and we should all think about planning ahead. The other way for planning ahead in relation to treatment decisions is by way of an advanced healthcare directive. So again, you with your capacity are saying what you want in relation to treatment if you're not able to say so for yourself later. So that's the other tool. We will actually have a template AHD which will be available on our website very soon because the Minister for Health has signed off on it. So that's the other tool when it comes to treatment and planning ahead. Next of kin, and what does it really mean? I'm nearly finished. It doesn't mean anything, and it never has meant anything, and that can seem very controversial and disruptive, but that has always been the true position. So the Act is not taking anything away here. It's not that the Act is saying that families are sidelined. The opposite, I think, is the case. As I've said already, families and those close to a person are the ideal candidates to step into one of the supportive roles if that's what's required. Even if they aren't in that role, then there is always an onus on an intervener, as they're called under the Act, to engage with people close to the person, to engage with them to find out what the person likes and wants and what their beliefs and values are. Not because you're saying you get to decide here. An adult has never been authorised to decide for another adult outside of a legal arrangement. It'd be really helpful if we all stopped saying next of kin, if hospitals, and I know they do, stop using that as a term, because it does create the idea that the spouse, the partner, the parent is authorised in some way to manage the decision making and to give or withhold consent. It just hasn't actually been true. But again, families are very far from sidelined under this Act. They are, ideally going to be able to step into these roles and will continue to have a voice regardless. I've just mentioned the results of a survey which show how widespread that misunderstanding is. So the Decision Support Service, that is us, we're a new statutory service under the Act. We are in the Mental Health Commission. That's the home that they found for us, but we have different functions from the rest of the Mental Health Commission. We take our functions from this Act, and they are broadly to promote awareness and confidence, provide information, register and supervise 3 of these arrangements. That's the middle tier, the top tier, and enduring powers of attorney. We'll have panels available to the court where need be. If there's nobody else to do it, the court can look to one of our panels to appoint a decision-making representative. And we have other visitors, as they're called, who help with some of our supervision and investigation functions. I'll mention the codes of practice in 1 second, and we have a duty to keep everything under review and to report back on what's working, report back to government. We don't do these things. So we don't make decisions for people. We don't directly appoint their decision supporters. We don't have a function to manage anybody's money or property. We don't provide legal advice. We're information and guidance. And we don't regulate services. We don't regulate other professionals. We regulate decision supporters only. So the code went out just before commencement in April. There's a general guidance code on supporting decision-making and assessing capacity, guidance for all of these new decision supporters, and you'll find them on our website together with a bundle of supporting documents. There's your guide to the codes. There are guidance documents on the decision support arrangements and how to enter into one, explainer videos, recorded presentations like this one, longer than this one, and lots of general information on the Act and frequently asked questions. So finishing with this then, and just some points which I think your questions will call out. The Act does not say that anyone suddenly has to enter into a decision support arrangement. And I hope your experience of the last 2 weeks has been that something seismic didn't happen. There wasn't this whole new era as of the 27th of April. Everything is going to depend on a person's circumstances and the particular decisions that they need to take. So it's not intended that carers are going to have to start applying to court to become DMRs just to get through everyday decision making. We say to people, think about how decision making is being managed now. Who are the other people in that triangle with you and your loved one? What are they saying about whether they think things have changed at all and how decision making is to be managed? We only have a role in relation to individuals and their families. If they enter into formal arrangements under the Act, that ongoing relationship will only arise. If you're in a formal arrangement, obviously we have a duty to answer your queries, and we're doing that already. Interaction with the DSS, registering arrangements and reporting into us is primarily across a digital platform because we've taken good education around that, including talking to stakeholders. And we do see that that will work best and most efficiently, but clearly with workarounds, we have to meet accessibility needs. And whilst people generally have very practical questions about money, whilst we're authorised to charge fees, none of them is more than €90 to register a co-decision making agreement or to notify us about an EPA, and we're authorised to waive those fees entirely when you're interacting with the DSS. There are no fees for submitting reports if you're under our supervision. So I will end there, Derval. Thanks very much. I think our website information, our queries information is probably available to attendees anyway, but that's where you'll find us. We have answered, I think we answered 180 queries on the first day. So we're getting through those by phone and email and pointing to people to the necessary supports and other information sources. So at your disposal very much. That is literally our job. I will stop there, Derval. I'm happy to respond to the questions. Thank you.
Thank you, Áine, for that. And that was so helpful to get an overview of where things are at right now, and just to bring us back, as you said, to those first principles of the Act and help us to understand that. And I think you've probably touched on a lot of the answers to some of the questions that came in advance of the webinar, but I will get a chance now to kind of go through some of those questions in a little bit more detail. But obviously, just from Inclusion Ireland's standpoint, you know, we have welcomed the opening of the Decision Support Service, and we do see it as a critical moment for people with intellectual disabilities in their recognition as rights holders. But we know for it to be successful and to work for people, family members really need to be empowered with information. And hopefully today, you know, some of those fears and concerns can be allayed so that they can support their loved ones more effectively, which is what all family members want to do. And we've really listened to people with intellectual disabilities over the last couple of years, as many really looked forward to the opening of the decision support service and for their capacity to be recognised as decision makers. But we've also heard some of those fears and concerns from
Sure.
family members, and change can be difficult and challenging. So that's why clear information is so important, and what today is all about. But I'm sure you've heard many of these concerns in your engagements over the last number of months. And what have you picked up when you've been meeting with families and meeting with organisations, and what do you feel it's really critical to communicate with families today, Áine?
Thanks for that, Derval. And it's some of the themes that I hope I touched on there. I suppose it's trying to reassure people that things suddenly haven't become very bureaucratic and complicated. Trying to correct that idea that here is a new thing and I have a new thing to do. Because life's hard enough as a carer. I know that in my past life, as a legal practitioner, we acted for carers and saw how hard it is every day to navigate the burdens of being a carer. So I wanted to correct the idea that here comes a new burden and new forms to fill in, and that it definitely has to mean that you have to do something formal right away. I think correcting that misinterpretation that suddenly everybody's capacity needs to be assessed, or that because a new framework exists and because your loved one has decisions to take around their bank account, they suddenly need to appoint a decision-making assistant. Now, you're not the only ones who might have some perceptions about the Act. We're hearing them as well from healthcare and social care and from the banking sector. So, it's very important that there is a good collaborative effort to correct those ideas where they arise. But I think fundamentally it's that don't panic. There isn't something very different that you have to do today that you didn't have to do this time in April. But I think look at the Act as offering supports where they're required, as a problem-solving tool, as a way to get around obstacles where obstacles arise, not that there is suddenly a whole new thing to do.
Great, that's really helpful, Áine, thank you. And I suppose in advance of the seminar, so we asked people as they were registering to send in specific questions, and we've grouped those under themes. And I'm going to share those questions with you today, Áine, and we can just have a discussion. So I suppose the first theme that came out from family members when they interacted with us is that there's this perception of families being excluded now from decision making because the decision support service is opened, and that now it's going to be providers and the decision support service involved in decision making, as opposed to family members having that role as they have always done in supporting their loved one. So I suppose the direct question, and I'm just calling out verbatim what has come in terms of the question, is I find that some agencies and individuals exclude me from sharing information regarding my family member. Do I have any rights to be present when doctors and other professionals share information to my family member, particularly when the information is difficult for her to understand and to query?
Yeah, and I think the end of that question is what helps us there, because the right is the right of the person to be supported in the way in which they want to be supported. If you and I choose to go to a business meeting and bring somebody with us, nobody says, what are they doing here? Yeah. Nobody says you're not allowed to have that person in the room. Here is somebody who has the presumption of capacity, who is well placed to say, I want my mother, my sister, my best friend in the room with me. So I've always found it quite difficult that people, agencies perhaps, or individuals or services might think, because this person is an adult, I'm now going to put the other adult out of the room. Adults are allowed to have the adult that they trust in the room with them. Subject to any valid concerns about coercion or something not being right about that relationship. So I think it's important to correct that view. As I hope I've spelled out today, families are not being sidelined under this Act, and that there is, in fact, it's set out in the guiding principles of the Act, that requirement, unless it's inappropriate, to involve those close to the family member and to make sure that they're part of sharing in the conversation. I would frame that not so much from the point of view of the rights of the carer or the family member to be in the room, but rather the right of the person to have them there.
Absolutely. And as you said, Áine, that is a universal truth. If we were going to get news in a hospital about our medical, we would choose to have a partner or a friend there, So So the same should apply here and does apply here. If the person really wants to have their family member with them, that should
That
not be.
there's no reason to put them outside the door. Some of the supports under the Act might help. It might be that, you know, a decision-making assistant arrangement will help there, so you're not constantly negotiating those obstacles and saying, like, here's somebody who literally is a decision-making assistant who has this authorized role to share information, explain it, help the person to communicate. It might shorten the conversation around getting to that place, but there's nothing, absolutely nothing, the reverse is true, nothing that this Act does that says families are sidelined.
Okay, that's really great and really clear, because that is, there's a reason I started with that question, is that that's probably the most frequent concern that we hear about. The second piece, and I think you've already named this, but I'll just call out the question again verbatim that we received. So it's about the obligation to engage with decision support service, or the perception that there is an obligation now. So are we legally obliged to apply for decision support for our family members with an intellectual disability, even though they can make day-to-day decisions themselves regarding their finances, day services, holidays, etc.?
No, short answer.
Right.
No, you're not. The DSS isn't the beginning and end of the Act, by the way. We have specific functions under the Act. A lot of what I've spoken about today isn't about DSS functions. We've a lot to do, but the Act is bigger than the DSS. And the Act fundamentally is saying if people are able to, they have the presumption of capacity, if they're able to make all of these everyday decisions, then you don't need to be coming near the DSS at all. And we aren't coming to you. The traffic is definitely the other way. We only have a role when a formal arrangement has been entered into.
Okay, that's really clear again. Thank you, Áine. The next piece is that we are trying to support, it's about supporting others to understand capacity and consent. So this again came directly from a family member. Do you have any advice or information on managing a team of personal assistants on decision support making with a 21-year-old girl who is non-verbal and has a physical disability? So it's really that, I suppose, in some of these maybe arrangements that people have as family members, they might have personalized budgets, they might, you know, and they might be working directly with a team of people who are supporting their loved one. So how do we, I suppose, support others to understand their roles?
Yeah, and we have a definite role there. And I mean, we speak across all the sectors, as you know, and we have codes of practice. I've mentioned there are 13 of them. So there are codes of practice for health and social care professionals. There's that overall guidance code on supporting decision making and assessing capacity. It's very noisy machinery outside my door. Hope it's not disturbing.
Okay.
So yeah, I would say if you're, again, it seems to be a kind of a third party piece here. If somebody doesn't seem to be getting the Act in whatever way, there is plenty of information. You can point them towards the relevant codes of practice, send them to us, because we have that function, not so much to advise, but to provide information and guidance. It's very clear that we've a role to do that. So if there's a job to be done in kind of making sure that people get the Act and what it says and what it doesn't say, everybody is welcome to contact us, and we can share our resources and answer direct queries.
Great, thank you. And a second one under the same theme is around, I suppose, I'll read out the question again directly. Any advice on managing doctors who do not consult or ask for consent regarding procedures also for a non-verbal 21-year-old girl with a physical disability? So, I suppose in an interaction with the healthcare professional, and you're observing as a loved one or a family member that they're not actively seeking consent from an individual, and not looking at that person's capacity to consent themselves, how is that? Any advice for those family members about how to approach that with the healthcare professional?
Healthcare professionals have loads of guidance around this, and in fact, even before this Act, the HSE National Consent Policy shows them the steps to go through. I don't know if the question is saying that, or it probably doesn't infer that the doctor should be asking for somebody else's consent, because as we've touched on, the consent of another adult doesn't arise. But there is lots of information both in the Code of Practice under this Act for healthcare professionals, and in the existing national consent policy, and in policy and guidance generally about the appropriateness of obtaining consent. Now, that doesn't mean a signature on a page. That means acting in a way which is consistent with the person's will and preferences. And all of this is capable of being managed and managed practically. And I'm not suggesting that suddenly, and we say this a lot to healthcare professionals, they need to go running to court as well to formalise procedures in order to access consent. And I can assure you lots of good work is being done to make sure that health and social care is up to speed in this as well.
Sure, great. The next question relates to, I suppose, the scope of the decision support service. And I know we all have high hopes for hopefully how this is going to transform a lot of people's lives who traditionally would have been seen as not decision makers or needing a lot of support to make decisions. But this is specifically around, the issues that I suppose a lot of people with intellectual disabilities face at the moment in terms of housing, access to appropriate services. And this is a direct question again from a family member, so I'll just read it out. I do not want my son ending up in an institution. He deserves a community home with his peers where he will have company and be able to attend his services, have outings and a decent quality of life. He should be in shared care now, but that is not available. So my question is, what plans are there to rectify these kinds of situations for people like, I'll just not call out this person's name. Will the new Assisted Decision Making Act tackle the issues like regular respite, housing, social inclusion, proper access to and continuous support?
I'd like to say the answer was yes, and it's not. We have quite a broad remit, but we're not a service provider. We, the DSS, aren't, and the Act isn't involved in those particular matters. So it can't address the housing situation. It can't ensure that the supports that people want and deserve are delivered. I'm afraid not. What it can do, I suppose, is deliver up the kind of supported decision-making arrangements which perhaps can give people a voice in pressing for these entitlements themselves, putting in place where necessary, somebody is able to support them in gathering up the information and expressing what they want. But making all of that achievable, I'm afraid, is beyond the remit of the DSS or the Act.
Sure. Thanks, Áine, for that clarity. And the next piece then is around, I suppose, the piece around the interaction between a service provider, an individual with an intellectual disability, and the family. And the first question that came in, and again, this is directly from a family member. We're trying to resolve a legal issue with my brother who has a physical and intellectual disability. Again, this is directly from the question. He doesn't have capacity to manage his financial affairs. His care is being managed by a Section 39 organisation who deem that he has capacity. We, our brother's family, have questioned this opinion and requested details of the methodology used to come to it. It hasn't been provided to us. What tools are out there to conduct a proper assessment to determine the level of a disabled person's capacity to manage their finances, for example? And what professional clinicians can use these tools to assess a person's capacity? So it's really that bit. I suppose there's kind of two bits to that. One is that interaction maybe with the service provider where the service provider disagrees with what the family member's assessment is. And then how, and then also the second part of that question is around what tools are out there in terms of how somebody's capacity is assessed.
Yeah, sometimes the questions that come to us from families do suggest a kind of a problem in the relationship between the service provider, the provider who's caring for their loved one, and a disagreement about whether the person in their care is able to decide or not able to decide. And this question suggests that the person has been found to have capacities. So on that basis, one assumes is making their own decisions. And here's a family questioning whether they really can and whether that really is what is happening, which is an unfortunate situation. And sometimes we do feel that people hope that the Act can be used by either party to kind of arrive at the solution, when the Act has to be about the person and a good outcome for the person. So, ultimately, there is the top tier route to court, which shouldn't be anybody's first resort. It should be a last resort. The court is authorised to make declarations about a person's capacity to identify whether a person has capacity to decide specific things. We're moving away from wardship and the idea of wholesale decision making by the court. But there is that route to court to say, look, here is a thing to be decided. What does the court think about the person's capacity to decide, and who should be deciding it? And that's not, as I say, where you go first. And are there tools for a person? Yes, there are. There's a way of doing this under the Act, as I've said, and there are supports set out in the overarching code on supporting decision making and assessing capacity. And clinicians and professionals have had lots of guidance around how to do this when they need to decide it, when they need to assess capacity. The starting point still being that presumption of capacity and supporting people as far as possible to make their own decisions.
Yeah, that's great. And then the second question under that theme is, I found it, and again, this is maybe about that relationship piece, as you've pointed out, and that, the decision support service isn't in the position to resolve the relationship issues between providers and individuals and family members. But again, I suppose it's interesting that this is the information that's coming in from family members. I found it extremely challenging to have any voice for my daughter since she moved into her own home. Service managers say staff are her advocates. Families are made to feel unwelcome. What can we do?
Yeah, I mean, again, it's about the daughter in this case, and in all of the other moving pieces, nobody can lose sight of that. Who does she want support from? The Act makes very clear that I do get asked sometimes, where are carers in this Act, where are psychiatrists in the Act? Lawyers ask me, where are the lawyers in this Act? And I have to say, it's not your Act. The Act is about the person and their rights and entitlements, including a right to be supported by whoever they want to be supported by. So as I think I've set out, families shouldn't feel that they are excluded under this Act. It's not the professionalisation of supported decision making. It's honouring and respecting the rights of people to be supported in the way that they are best supported. So again, it does sound as if there's a kind of a relationship issue here. The Act may not unlock that necessarily, but I will always bring people back to the person and their rights, their will and preferences. And if that's, I want my family here and I want them part of the information sharing, then that's a good starting point, and that for negotiating this whole relationship. So I'm not saying that the Act, certainly not the DSS, can wave a wand here, but I think nobody should lose sight of that.
Great, thanks, Áine. The next piece is around court application and means testing. And again, this comes up quite frequently from family members contacting us. So why is it means tested for persons applying to the courts to be recognised as DMR? I feel this should be income related to the person with the disability themselves. It should not be applicable to family members or friends. We are her family, but we do this in order to give the person with the disability a voice. We should not be penalised for endeavouring to give support. It makes no sense.
Yeah, the application is to court, so it's not to the DSS, so we don't own that bit of the Act, and you're probably talking there about Part 5 of the Act. Now, the court rules were published last week, I think, and if they're not up yet, I think they probably are. They're accessible via our website, so we're not involved in the court part of things at all unless they ask us for a panel decision-making representative, and we could be involved as an outcome of the court process to supervise whatever arrangement is put in place. In terms of the means testing there, I think what that question is asking is about legal aid. So that the applicant to the court is subject to financial criteria in applying for legal aid. The person who's the subject of the application is entitled to legal representation. I would point people to the Legal Aid Board there, and I think if we don't have it yet, then that's to law centres who are able to offer support, but I'm afraid that is outside of the control of the DSS. We have said, don't put families in a position, please, if you can help it, and how generous can legal aid be? I mean, I would think it would be unfortunate for people who are best placed to bring the application face cost barriers in bringing the application. But I'm afraid, whilst we have said a thing or two about it, it's not something that's within our control. But if people do have queries about the court process, and I think the next question is about it, about the court process, about accessing legal aid, we can signpost from the DSS, but we're not the key players at that part of the Act.
But that's helpful, at least, Áine. Thank you for clarifying that again. Yeah, and you're right. The next question is around DMR and the pathway for moving forward with DMR. And the second part of that question is, do I need to pay a solicitor to make this application to court? So again, related to the fees, etc. But the first one is the pathway. And
yeah, so that's if you are at the top tier, and if there are a decision or particular decisions that need to be taken, then there is an application to the circuit court, unless there's, in some instances it's the High Court, but that's quite a narrow exception. It's if it's about life-sustaining treatment or living donor organ donation. You might never see one of those. Otherwise, it's to the circuit court. And as I say, the circuit court has rules and forms about how you bring that application. And if you can't find them on the court service website, we'll have pathways to them on our website. But again, it's not an application to the DSS. So this is when somebody has decided, here's a decision which can't be taken in any other way, and this is the problem that I need to solve, because the court will ask that, what else have you done before coming here and looking for a capacity declaration and the appointment of a DMR. And when you are across the door, well, let me say the form includes a capacity report as well. This is a form which I think they're calling a 55A. Sorry, it's not short. We might try and work with the courts and maybe some kind of accessible version of the form, or at least some guidance around the form. Don't want to overpromise because they own the form and we don't, but let's see if there's something that might be done with that. But it's a form to be filled in. One of the documents that you need is a statement in relation to the person's capacity from a medical or other healthcare professional. You're asking the court to make a declaration about the person's capacity, and if they find that the person doesn't have capacity, to move to next steps, which could be appointing a decision-making representative to do particular things around making that decision. That's when we might come in. They might ask for a panel DMR. Ideally, it's going to be somebody in the life of the person. And then any DMR, whether panel or family member, whoever it is, has a duty to report into us, and we'll support them in doing so. There's templates for reports, and they're under our supervision. So that's a kind of a snapshot of how the DMR process works. There's an explainer video on this on our website, and I think a how-to guide as well. You never need a solicitor to go before the court. Anybody's allowed to go into court without formal legal representation in any sort of a court. And I think it touches on that earlier question about whether legal aid is available. The Legal Aid Board covers all aspects of the Act, but there is that means test if you are not the person. The person doesn't have to qualify in a means base, but I'd refer you to the Legal Aid Board to find out more. And again, we can try and point you in the right direction.
Great. And look, after this webinar, we'll obviously send out the recording to anybody who attended and more widely circulated as well. And we can, at the end of that, attach any of those points that you've raised, Áine, or the links to anything that would be appropriate for families to access. So thanks for that information. I suppose the final bit before we go into, there's a couple of questions that come in as well, have come in under the Q&A live as well. But just, this is the general point. This didn't come in directly from family members, but it's something we've observed and we frequently hear. And you've touched on this in your presentation as well. Like, we sometimes hear family members say things like, my son or daughter has no capacity to make decisions. And I suppose at Inclusion Ireland, we often try to open up conversations about this, just to have a respectful and open conversation. And to us, no matter what level of support a person might happen to need, and they do have some capacity to make decisions. And, we often use this example of where a parent might say, my son couldn't possibly make a decision about where he lives. He's non-verbal and has a lot of care needs. But when we talk it through and look at the person's will and preference, it becomes clear that even though the person might be non-verbal or have really significant support needs, they are able to communicate their preference, things like, I don't want to be in a noisy house. They really don't react well to that, or they like being in the countryside, or they like being near their family. So we're just concerned that family members of everyone who has very significant support needs will automatically think that there needs to be a court-ordered, DMR. So can you talk us through this? Is that something you're picking up as well? Talking to family?
Okay. Yeah, we come across this, so that certainly I have heard people say, and say in good faith, look, I have known this child of mine my entire life, and I can tell you that they don't have capacity. So we have to say, there's no such thing as does not have capacity. It's always capacity to decide what. And people can sometimes in exasperation say, look, I'm telling you, that they really cannot make the decisions, and that their ability to do so is really, really, really limited. But often exactly the same person will say, but I know them best. I know what they want. I know what they like. So the two things can both be true, that when if you think about kind of the idea of supplying consent or being able to sign a contract, that's one thing. But it can, the same person who can't do that might be very well placed to make their wishes and intentions known to somebody who knows them best. And it's often the same person could be saying both things to us. My child can decide nothing. I know my child best, and I know what they like and what they want. So do you see what I'm getting at there? That in that kind of space of knowing somebody, knowing their will and preferences, being able to respect their decisions, you can often still get to where you need to go. And I'm not saying that will solve all the problems. So when we say, when do we need to go to court? I think, again, it's something I touched on earlier. What problem are you solving by going to court? Have you come across an obstacle? Have you hit up against a third party who is saying, for example, your child can't inherit that money from their grandmother, because who am I supposed to hand it over to? We definitely need to formalize this, and that could be true. So you will sometimes encounter situations where, yes, the formal support, the clarification of capacity, somebody who's able to step into that formal role will be required. But getting through the day to day with somebody that you know and love and whose will and preferences you're able to interpret should very much still be a doable thing, it seems to me. There was a bit of a helpful example with the rollout of the COVID vaccine campaign. I sometimes draw this as an example. Those people weren't all made wards of court. People didn't agonize about getting somebody's signature on a page in order to be able to administer the vaccine. The High Court President herself said, don't come to me trying to make these people wards. The law about the vaccine said, find out about their will and preferences, do what you can to facilitate communication, however the person communicates, and you'll get to where you need to be. So the lens, I think, is the decision to be taken, not here's a person with hugely complex support needs. Do I need a badge in order to be able to negotiate what we've always done before? It's rather, what are the decisions? How are they to be taken? And is there a new way that needs to be managed of taking those decisions? So these are precision tools for solving problems, not the old blunt instrument approach that we had before.
That is so helpful. And that's certainly something, we're going to continue to have that conversation with people and reassure people around that. As you said, like the courts, etc., it's the last on the list of things to do. And it's where there's a problem that needs to be solved. If things are ticking along great and the person's will and preference is being respected, they're making day-to-day decisions, things are good, it's where there's a problem. That's where that kind of support might need to kick in. So that's really, really helpful, because we are concerned that people think, oh, my son, my daughter has really high support needs. It's an automatic need.
Yeah, there was definitely that narrative at the start. And I mean, I'll say to whoever needs to hear it, whoever needs reassurance around that, I fully expect, as I always say, to be talking about the fundamentals of this act forever. As people, people change, people move into the kind of sphere of the act, people move out of it. So we've no problem at all coming back to those first principles every time.
Brilliant. So listen, I'm going to just look at our Q&As that have that have come in. Some you've probably already answered, but I just might take a couple of samples there. So one is, what data protection measures will be in place when formal arrangements are entered into with the Decision Support Service?
Plenty, because we've been round the houses with the Data Protection Commissioner on this. We've done a full data privacy impact assessment and got a clean bill of health. So though our register of formal support arrangements is very much subject to all of the data protections that you would expect, and it's searchable only by people who have a legitimate interest to search it and satisfy us of that, or who qualify as members of bodies and classes of professional who set up accounts to be able to search it. So we were with the Data Protection Commissioner a lot over the last couple of years, and as recently as this week.
Yeah, that's great. And there's another really this example, which I think it's probably relevant for a lot of people on the call. I have a 30-year-old daughter with an intellectual disability and epilepsy, and I and my husband are constantly making decisions along with her neurologist and psychiatrist about what medications to try. She would not have capacity to make decisions on any of this. Again, I'm just reading out this verbatim. Will we be able to continue making these decisions without consulting DSS?
I think a starting point there is to say, ask the neurologist and psychiatrist what they are saying about that. Is it possible to continue as they have been, acting in good faith and for her benefit, acting in a way which respects her will and preferences? Or is it their perception that they have to do something formal in order to proceed or not? And that they will get really good guidance on that. I mean, the healthcare professionals will, from the HSE National Consent Policy and from the HSE National Office for Human Rights and Equality, who have a bundle of supporting guidance around this. So I would say, rather than coming to our door, ask the other professionals in the room whether this is to be interrupted or whether they think something different needs to happen.
Yeah. Okay, thank you, Áine. So again, this is about wardship specifically, and you did mention that at the beginning, that people might need to contact the Decision Support Service to get specific information around this. But in supporting someone to make an application to discharge their wardship, and instructing a solicitor to do same, will the solicitor take the instruction whilst a current ward of court without the committee's agreement?
Any ward is authorised to make their own application to court. So too can their committee, and with the leave of the court, so too can somebody close to them. Any ward of court is at large to initiate their own application under Part 6 of the Act. They don't need the permission of anybody to do so.
Okay.
Am I answering that? Yeah. Will the solicitor take instruction? Yeah, they should. They should. The ward is allowed under Section 54 of the Act to commence their application for discharge from wardship. Okay,
great. When a person has an ongoing medical negligence case and also has an intellectual disability, what happens as they will now not be made a ward of court?
Okay, so that's possibly in anticipation of an award of compensation at the end of this. That might be the subject ultimately, if all else failing and everything else has to be tried first, that in order for the money to be paid over and managed thereafter, it might become the subject of a Part 5 application, so the DMR would be appointed with responsibility for the person's property and affairs, including any award of compensation.
Okay.
So where it would have been the route to wardship after that, that's, as the questioner says, not an option.
Yeah. Okay, that's clear. Thank you. Another question and I think you've answered this in your opening about legal advice, which you don't do.
We don't.
Does the DSS provide legal advice on how best to make a will, providing for the future of their child with an intellectual disability?
We do not. We do not. And there are ways and means there, which would be as they were before.
Yeah, that's great. Okay. And this one is about, again, and I'd say this is probably a familiar territory, and hopefully the Decision Support Service is going to enable some changes in practice around this as well. But we currently manage our adult son's finances. He knows he has money, but would not have an understanding of the value of money. Can we continue to do this? If and when he wants anything, he purchases freely. Is there anything we should be doing in relation to this matter?
I think if it's not broken, don't. We do work with the kind of the banking sector as well to make sure that they're not reading the Act back to front. Do you know that tendency to think that, they suddenly need to start assessing capacity or insisting on formal arrangements? Because the person has the presumption of capacity, entitled to the support of whomever they choose to support them, provided that's respectful of their will and preferences and all of that. Then if again, I don't see that there's a need immediately to formalize, but it's that kind of who's the other person in the triangle again, isn't it? If the bank starts saying something different, you can let us know if you like. We can't make them do something differently, but we do have a role overall to promote a good understanding of this Act, including in professional sectors. So if this is somebody who has effective control over their own finances with support, then it doesn't sound to me like it needs to change. But again, who's the other person in the room? Are they saying something different? Are they wrong? And we can support around that if need be.
Yeah. So there's just two more briefly, and then I'm just conscious of time and we'll wrap up then, Áine, and you've been very generous with your time, so thank you. So this is from a parent again. I feel the need to apply for my daughter who is currently in her own home, which is a HIQA designated residential centre. Services currently saying that staff are advocates. When my daughter was going for a hospital surgery, I was told no need to attend. only for next of kin, I would have been excluded. I see the way forward is to have DMR in order to have input and advocate. This is, again, the person's direct words. There is no other way. And direct words, again, the services do not want families currently.
Okay. Right. It's back to the daughter, isn't it? What does your daughter want? Who do they want there? They're entitled to have them there in the same way that you and I are entitled to have a loved one going for surgery. It seems to me this points again to a relationship problem with the service, which needs correcting somehow. But and I know that somebody's saying if it weren't for next of kin, I wouldn't have been allowed. No, the healthcare professionals moving away from the service for the moment already know under the HSE national consent policy about the importance of involving those close to a patient, with a view to understanding the patient as a means of accessing what the person's beliefs and preferences and will and beliefs and values and will and preferences are. So again, it's not I have a right as a family member to be there. It's what is the right of the person, in this case, the patient, in terms of their natural support network. I don't think we can get more into correcting the relationship with the service provider, but I think that the Act is not either getting in the way of that role of families, and it seems there's a separate conversation to be had with the service provider, but medics do not put families out of the room, or shouldn't, under existing pre-existing law and policy.
Great. This is a kind of a technical one. You know, the guidance says that the owner employees at designated centres where a person resides may not have a formal decision support role. What about owners and employees at day services or other non-residential, non-designated services? Can they hold a formal decision support role?
Yeah. The starting point is the person in residential services, and things flow from that. Do they want to? Will they have policies on this? Should they? You know, that's something for individual services to consider, but the exclusion relates to when a person is in residential services and the owner, registered provider, an employee, or anybody who lives with any of them not being able to step into the role unless it happens to be their own family member. But yeah, are they in residential services or not? And then it's over to the service whether their people working there would do it.
Okay, that's great. And then just final, and again, this has come up and we've explored this in terms of people with really significant support needs, who may be, you know, non-speaking, have very significant care needs. And again, you know, this concern or worry from family members that, you know, that my child has no way to express any will and preference to have family support. So what then? So I guess, again, it's back to that conversation we're trying to have with family members at the moment about that, you know, it's a rare situation that somebody can't in some way, shape or form, even the most significant support needs, can't tell you as a loved one what they like and don't like in their lives.
Yeah. And I think, again, it's, well, what decision space are we in here? What is being decided? And I think the question is saying that my daughter has no way to express her preference to have family support. So there's a concern here that, well, why would the presumption go the other way? Just thinking out loud here, why would therefore any third party conclude that, well, that must mean they don't want you in the room? You know, why would that be intuitive? And as I think you say, Derval, in most cases, now I always get wary in these circumstances because it sounds as if I'm making judgments about what a person's real life experience is, and of course I don't know. But as you say, Derval, the opportunity is often there to know what a person likes and wants and whom they rely on and whom they support and whom they're comfortable with. So the fact that somebody who is non-verbal with very high support needs isn't able to say out loud, please keep my mother in the room, doesn't mean that it's beyond the wit of anybody to realise that they would rather have their mother in the room, and the presumption should not be that they do not want their mother in the room. That's how it would strike me. But again, I think this hints at a kind of relationship problem which perhaps needs to be fixed in a different way. But I would say this Act is not getting in the way of a common sense way forward.
Sure. That's great, Áine. So I think we've answered all the questions that came in advance, and we've also answered all of the questions that came in through the Q&A. And thank you. I'd just like to express my thanks to all of the family members who engaged with us and took the time to send in the questions and their concerns. I hope that this has gone some way towards allaying some of those fears or concerns, or at least pointed you in a direction where you can look for more information and support. And as Áine has said, you know, if there's follow-up questions or things that you're worried about, that's exactly the role of the Decision Support Service, to help you through that, and to talk about your own particular set of circumstances with your loved one, and to tease that out a little bit more. I think the thing that's striking me today is that, you know, there isn't a need for a big rush to course for everybody. You know, it's about looking at, are things working now for you, for your loved one, and particularly for your loved one around their decision making day to day, and how they're managing their life and their the decisions that they need to make to have a good life. The courts and that are the last case scenario, and where there is a problem that needs to be solved. So I think that's really clear information today amongst and I hope that families have heard and had their questions answered as best we can today. But as you said, Áine, this is going to be a work in progress. We're going to be learning all the time. And I think that's so important that we keep the conversation going over the next few months, and, you know, potentially that we would do a check back in a few months with the learning that has happened so far.
Let's do,
that would be really helpful. Is there anything you want to say just to wrap up, Áine, before we finish the
No,
webinar?
just thanks again. And this is what's really useful for us. So, you know, our thanks is due to you as well, because we see ourselves very much as a public facing service, and we can only know that we're getting things right and providing reassurance, allaying concerns, offering practical supports when we hear from people. So I think our work will definitely continue, as you say, to provide that reassurance and correct some kind of misreadings of the Act where that's necessary, but really happy to continue to do so, and we'll keep the conversation going.
That's great, Áine. Thank you, everybody. We're going to end the webinar now with our thanks.
Thank you all. See you soon. Bye-bye. Bye.